something to call on?
Sorry, sir, I was calling. I didn't realise my microphone was on mute. I'll do it again.
Very good.
Friday the 15th of May 2020, the Queen on the application of Hoareau and another versus the Secretary of State for the Foreign and Commonwealth Affairs, part heard. Recordings of the hearing are not allowed apart from those of the court. Thank you.
Thank you very much. Sir James.
Well, can I make the usual checks? You can see at least here.
Can't.
Yes.
I can't see you yet, but maybe others can.
I can see you. Yes, so can I.
Right, well, for some reason or other, I'm the only one who can't see you, but again, I don't think it matters because you're certainly very clear and audible to me.
Good. As long as you can hear, hopefully the vision may come.
Yes, quite.
My lords, I've got a bit to get through in the time left to me. I wanted to finish off one point from yesterday, which related to peremptory norms.
Yes.
And it addressed what type of norm or rule under international law is the right of self-determination about which the ICJ were opining. And I returned to that briefly, in part because of the questions that my Lord the Master of the Rolls asked yesterday, and in part because the case against me asserts that there is a breach of a peremptory norm because it is said it carries the consequence of non-recognition, a requirement of non-recognition flowing from the fact that it's a peremptory norm, and that is then used against me as a weapon, in effect to invite this court to non-recognise and or to invite this court to conclude that the Strasbourg court would non-recognise when you're arguing about either anxious scrutiny and or the meaning and effect of Article 56. So it may just be worth doing the hierarchy very briefly, and forgive me if this is all very familiar territory. Customary international law, just to start with that as a concept, customary international law is the general practice of states accepted as law. And so it is a way in which international law is created. It sits alongside treaty law where states agree things, but it is a general practice of states accepted as law. And it therefore requires, well established, two elements: a general practice among the states and a sense of legal obligation, or opinio juris, as it's put.
Sorry, could you repeat that? It's a general practice, and the second point was?
A general practice and a sense of legal obligation, or opinio juris. We'll be seeing the phraseology in some of the cases. But the ICJ explained this in the opinion of paragraph 149. If you wanted that explanation, on page 1716 of tab 36 of bundle 2 of the authorities.
All right, page 1716.
1716, behind tab 36, paragraph 149.
Thank you.
This is just a basic explanation of how the hierarchy works.
Yes. Yes.
And of course, CIL, if I can call it that, is binding on states on the international plane. It's law established by custom, as its title suggests. But it's accepted into their domestic legal systems in a variety of different ways, depending on whether they're monist systems or dualist systems. And in the UK, it's not automatically incorporated, as I'll come to. And so here we have the ICJ opining on the right to self-determine in the context of a colony becoming independent through the process of decolonisation.
Yes.
Finding that right to self-determination was customary international law. See paragraph 150 for some of the things that were relied on to reach that conclusion. So there is a customary international law right, but it's of that particular and specific kind. So it's about decolonisation of entities which were formerly colonies, and specifically here, the process of decolonisation and the split, as it were, the territorial split of BIOT from the previous territory that was Mauritius. It's not therefore about a right to resettle or a right to live in any particular part of the territory subject to that decolonisation. And by normative character, which I think was the Master of the Rolls' questions to me yesterday,
Yes.
at 151, having the status of a customary norm. You could use norm or rule or principle. So the ICJ does opine that self-determination in that sense is CIL. But, and it's a pretty important but, there is a sequential question. So customary international law is one of the ways in which international law is formed. The question that then arises is one of characterization. What type or character of norm or rule or law is it? And that is or may be important because international law ascribes certain consequences to types or categories of norm or law. So these are, if you will, if you think in graphical terms, these are concentric circles within customary international law. And the first of those, the tightest of them, is a peremptory norm, or jus cogens. That's a small subset of customary international law laws. And its characterization as peremptory, or as jus cogens, is significant because a, quote, serious breach, I'll tell you where the quote comes from in 1 second, a, quote, serious breach of a peremptory norm gives rise to specific international legal consequences. And they are the very consequences that the applicant seeks to invoke in these proceedings, specifically and in particular, an obligation of non-recognition on states. And so the applicants or the appellants here say on this court and other international courts as well. Those are the consequences that are set out in Articles 40 and 41 of the ILC articles. So if you have the bundle of authorities with the advisory opinion in it, if you go to tab 38, starting on page 1886 in the electronic, and you go to the pages that were added, you will find Article 40 at 1887, 1887/3. And you will see what its terms are. Left-hand column in the bold, in the middle of the page. My lord have them.
Yes. Yes.
So it's telling you what it's dealing with. It's dealing with a serious breach of a peremptory norm of general international law, and a breach is serious if, and then it defines what is serious in the second. But the consequences of there being a serious breach of that kind, of a norm or rule of that kind, are then set out in Article 41, which starts in the right-hand column over on the next page, 1887/4. And in particular, in Article 41, sub 2, left-hand column on page 1887/5, no state shall recognise as lawful the situation created by a serious breach in the meaning of Article 40, nor render aid or assistance in maintaining that situation. Now, if you go back to the advisory opinion in tab 36, and you go to paragraph 176 in the opinion, on page 1723. You will see that the court was confronted. See the second paragraph on page 1723, i.e. the third subparagraph of 176 of the opinion. As regards the consequences, do you see that?
Yes.
On page 1723,
Yes.
they were directly confronted with the argument by Mauritius and others that it should declare the right to self-determination as a peremptory norm and give the opinion that states should not recognise the situation created in BIOT. So in other words, they were invited to conclude that it fell within Article 40, and that the consequence was therefore the consequence in Article 41 sub 2 that we just looked at. And they declined to do so. They did not declare it to be a peremptory norm. They did not call for collective non-recognition in any of their paragraphs that follow 177 and onwards, or specifically in the reply that they gave at 183. He did not offer, therefore, the opinion that Article 41 was in play, with the consequence that third-party states or anyone else had the non-recognition obligation. And if you want crystal clarity in relation to that, it comes from the fact that there was evidently a disagreement about that issue. And that was one of the reasons for one of the three, if not all of the three, not all of the three, but you get it most clearly from the one I'm going to take you to, of the separate opinions, which the court obviously did not go with, which is why they were separate opinions. Go to Judge Sebutindi's opinion, if you would, tab 37, on page 1846. Perhaps pick it up at 1841, where you see the issue being confronted in very direct terms. Look at the title at the top of page 1841, the status of the right to self-determination. I emphasise this is all self-determination of the kind they were dealing with, but the right to self-determination as a peremptory norm. And you'll see what is being considered. And the view of this judge, look at paragraph 31. That's what she thinks should have happened. On page 1841, paragraph 31. You see the context that she's talking about, which is obviously limited, but it doesn't matter for the purpose of this point, the beginning of paragraph 32. And then she analyses why she thinks, or in her view, it's a norm of that kind. Then she goes at 44. You see the issue that she's confronting, sorry, 32, and also the first sentence of 40. Then at 44, on page 1845, she comes to the second question. You'll remember from Article 40, is it serious? And concludes that it was. Again, you see none of this reasoning in the body of the opinion of the court. And then look over at paragraph 45. And you'll see her opinion. And you'll note that she notes that the courts, in her view, failed to recognise the peremptory status. And the consequence is that it doesn't have the sort of clear implications that she put it, including, for example, for the United States and the United Kingdom. It doesn't have the sort of clear consequences that she would have wished. And what she's doing in 45 is effectively setting out the consequences that would flow if it were to be found to be a peremptory norm, or might flow from that, of the kind that you've seen already set out in Article 41(2). To go back to the opinion behind tab 36.
So this is all, her name is Judge Gacha, is that right?
Oh, I'm so sorry, I missed the beginning of that.
Have I pronounced her correctly? Judge Gacha? Gaja?
No, it is, I think, in Judge Sebutindi.
Oh, I don't know. Where does that start? I was looking at 1827 for the beginning, but have I got the wrong one? Where does her...
Sound isn't very good. Just to check we're on the right place, it's probably an important point. 1846.
1846.
Were you there?
Now, I got 1846, but I want to find out where the judgment begins of this judge.
1830. 1830 is where it starts. Sebutindi.
1830 is where it starts.
Ah, thank you very much. Yes, thank you. Sebutindi.
Does that help?
Yes, thank you.
I'm sorry, your sound isn't entirely clear, but forgive me. Just to go back to the opinion of the court behind tab 36, at page 1723. The court did recognise, as we see in 180, on page 1723, it did recognise that the right to self-determination of the kind it was talking about was a norm with an erga omnes character. Meaning, as they explain in paragraph 180, that all states have a legal interest in protecting that right. And again, just to put this in context, erga omnes norms are also a subnet of custom international law norms, but constitute a larger category than peremptory norms. So they're the second concentric circle out from the centre. And what they normally involve, as that sentence indicates, is the ability of states to take up the cudgels, if I can put it in that way, on behalf of the entity which has been wronged on the international arena, if it can't or won't or hasn't the facilities to do it for itself.
I mean, your Latin is much better than mine, I'm sure. What does erga mean?
Sorry, my lord, the sound is cutting in and out.
Right, what I'm asking you is, I'm saying your Latin is almost certainly better than mine. We all know what omnes means. What does erga mean?
Sorry, I didn't get the question.
I wonder, is everybody else having difficulty hearing me as well?
No, I can hear you well. Let me try, Sir James. What the Master of the Rolls was asking was, what does erga mean rather than ergo?
I think in Latin,
What does erga omnes mean?
it just means towards everyone or towards all. And
Yeah.
it's the same doctrine that we have in European Union law. It applies to references of judgments of the European Court. They apply to all the parties.
My lord, will you pause for a moment? I'm sorry, my sound is breaking up. Can I try logging on and logging off again? It may be me.
I think it may be you,
Will you
yes.
forgive me if I try that thing?
Yes, do, yes, do.
If I can't, very helpful. Give me 1 moment, if you will.
Let's make sure everybody else has cancelled there.
Rather.
All right, I can see there are a number of people who are not the judges and are not you, Sir James, who are on this remote hearing, who have not cancelled their microphones. It's really important in order to get proper bandwidth for everybody else here. Can please all people who are guests on this remote hearing, who are neither the judges nor counsel speaking, would you please mute your telephones, your microphones now? Thank you.
Well, I can certainly hear you better, having gone off and come back on again. So,
Yes.
will you forgive me if I ask you to repeat the question?
Yeah, well, I think Lord Justice Green has given us the answer, but I was asking what exactly does the Latin erga mean? And he says it means towards. And he then continued to say that that's also the principle for some EU law.
Yes, well, my lord, I'm certainly not going to take up the cudgels against Lord Justice Green on the Latin meaning. That's my understanding too. But what it imports is an ability to take up the cudgels on behalf of others, because this is a principle which all states should respect. But it isn't a peremptory norm. It doesn't come with that non-recognition obligation that you saw in Article 41.2, which is restricted to serious breaches of peremptory norms. Now, there may be other obligations, and if you go on in fairness to this judgment, keep saying judgment, I keep being told off behind the scenes for saying it, in this opinion, the second half of paragraph 180, you will see that they do refer to what looks like an obligation of some description for the General Assembly to pronounce on the modalities required. All member states must cooperate with the UN to put those modalities into effect. It's not clear to any of us what the source of that obligation might be, but it may well be that it's an obligation that they seek to derive from the passage they then quote over on the top of page 1724. But in any event, it matters not terribly. That is not an obligation of non-recognition of the kind asserted against me that would flow from a finding of peremptory norm. That's what Judge Sebutinde was griping about. Her problem was that the court had not gone far enough. So there was evidently a disagreement which the three other judges who gave separate opinions lost, as it were, and the court produced the reasoning that it did.
So James, can you help us with this? It may flow from the point you're making, or perhaps something you're going to come to. That we've been asking ourselves what the consequences of the opinion resolutions are, assuming for the sake of argument that they correctly express the law. I know the United Kingdom doesn't agree with that. The general tenor of the opinion and the remedies that it seeks and of the resolution are essentially forward-looking and prospective. We've been trying to get our heads around what that implies for all legal action which might have occurred over the last X years, and what that then might mean for the meaning of responsible. We know that in domestic administrative law and in various international law regimes, you can have a difference when you have a found illegality or unlawfulness between prospective and retrospective effects. What do you say the tenor of this opinion is, assuming for the sake of argument that it correctly expresses the law? What is it?
My lord, you won't be surprised to hear me say that this is on its own face and on its own terms prospective. And I will come back to this, particularly in the context of Article 56, because the alternative, that this is, as it were, forever declaratory, would run into massive historical problems. It would mean, for example, that I'll come to this point specifically in relation to Article 56, but the very basis on which Article 56 was intended to operate when it was Article 63 could never have happened, because the tenor of the flow of customary international law has been against states holding colonies and in favour of rights of self-determination in that sense. So it would be almighty problematic historically were, as it were, the common law declaratory theory to be introduced into this arena. And as my lord rightly points out, there are in many, if not most other systems, there is the capacity within the legal system, even if sometimes it chooses the declaratory theory for some things, to make rulings prospective. I'm sure my lord will have in mind EU law, which has that, and certainly the ECHR does too. Think of cases like Marx and Belgium. Do you remember about the wills, where everything would have to be unravelled going back to the year dot if they allowed illegitimate children to inherit and so on? So my respectful submission is that even on the premise that my lord puts to me, there is a clear answer here, which is that this is prospective. Just bear in mind the words as rapidly as possible.
Well, it gives us a 6-month transition period.
And it gives it at the very, of course. So my respectful submission is what they're not doing. And it wouldn't fit with the reasoning, because at some point when they're analysing when this sort of right came to be recognised, the very basis on which customary international law comes to be recognised is accretive. If I can put it that way. It can be, as it were, a build-up of state practice, an increasing recognition among states that something is a rule, something is now a morally and properly acceptable thing in international law, and that they're agreeing to be bound by it. So the very process by which CIL is created is against a rigid application of the declaratory theory that the common law brings to bear. That's my answer.
So that may not necessarily get you home on the facts of this case, given that the operative UN declaration, which was I think 1514, was in 1960 about self-determination. But when you just read, I mean, what we're trying to understand is how to read both the opinion and the resolution, assuming, and again we know you dispute this, assuming that they fairly and properly reflect the law. Then I'll ask ourselves, what are the consequences in law of that? Are they prospective, or do they cover retrospective actions as well? And if the latter, what does that mean for responsible? We obviously understand your position.
My lord, in my submission, it's plain that they are prospective.
Thank you.
That's plain from the consequences analysis that the court brings to bear, and it's plain from the way in which it invited the General Assembly to deal with it, and it's also plain, it's a consequence or a sidewind of the points that I've been making about peremptory norms. We're not even in non-recognition territory. We're in territory where they're identifying specific things that might need to be done in the future. So that's how we put it. So we're going to move on to the impact on common law. And again, this is at some level of generality. I'm dealing with the impact at common law, even if there is a CIL proposition established. And as you know, customary international law is not automatically incorporated into the common law. You will recall, it was the passage I took my Lord the Master of the Rolls to at the very beginning of my submissions. You will recall paragraph 66 of Lord Hoffman.
Yes.
Expounding the monist theory of domestic law. Again, I'm not going to go back to it because I'm sure it will be familiar to my lords from other contexts, but the most recent or the most modern consideration of this issue was in the KU case, KUIU, 4 volume 1, tab 19, page 624, and you probably just need one paragraph, which is Lord Mance, at paragraph 150. I think that's the 682 page reference, I'm hoping, supported by Lord Newberger and Lord Hughes. And he effectively said, without turning it up, that once it's established as CIL, that can shape the common law whenever it can do so consistently with domestic constitutional principles, statutory law and common law rules which the court can themselves sensibly adapt without it being, for example, necessary to invite parliamentary intervention or reconsideration. So it's a guarded yes. It builds on Lord Bingham Jones, who said it was a source, I think, in the approving an academic article by Professor Brearley, said it's a source of domestic law rather than being simply dragged in automatically, which had been the Lord Benning theory in Trentex. But you get to Lord Manson KU and you get that very careful expression of principle, very careful on the basis that there are constitutional constraints operating on the courts in the usual way, including leaving things properly in Parliament's province to Parliament, not overriding statutory law, not overriding constitutional principles, like it's only for Parliament to create criminal offences. And there are, we submit, key constitutional constraints in play here. First, there is a careful legislative scheme governing settlement, citizenship, and all of that in the BIOT. The BIOT Constitution Order, now lawful under Bonku 2, says there is no right of abode. The BIOT legislation, in the form of that order and the 1965 order, does not contain any form of BIOT citizenship, even without rights of abode. There are, as I indicated earlier, in the 1971 Immigration Act, there is specific parliamentary dealing with rights of abode and citizenship, but in the UK, not in the BIOT. And Section 6, the British Overseas Territories Act 2002, Supplementary Bundle 2, tab 28, or page 28, confers on British citizenship on Chagosians meeting the relevant criteria, as I pointed out. So the first set of constitutional constraints are that there is already legislation properly made and lawfully made governing these issues. And that does operate as a serious constraint on, per Lord Mance, paragraph 150, to the reception of customary international law into domestic law anyway. Secondly, by way of constitutional constraints, it is under the system which we are dealing with ICJ opinions and General Assembly resolutions and all that, it is properly under our constitutional arrangements for the executive to decide how, if at all, it should react to such advice or those resolutions on a recommendatory basis. And it would be wrong in principle and in policy for the English courts to preempt or supplant any response to the advisory opinion from the executive, a fortiori any response to the General Assembly resolution. And this principle has a pretty well-known and long-established statement attached to it on the basis of the statements of Lord Atkin in Arun Salzo Mendy, Supplementary Bundle of Authorities 35 at 43, where Lord Atkin said, our state cannot speak with two voices on such a matter, the judiciary saying one thing, the executive another. So there are serious and live issues about that.
So can I just ask a question about that? So,
yes.
We know, I think in the present case, I don't think it was taken as to it, but I assume is there a formal response of the executive here, of the government here, to the opinion? I don't think we've been taken to it.
My Lord, I don't think there's anything formally that's been put out by way of statement. I'll check whether there is anything formal.
I mean, we have been told, I think you've told us, and I think we've been assuming that the government doesn't agree with it. But I mean, what's that based on?
Well, my Lord, it's based inter alia on the fact that the resolutions ask for certain things to be done within a certain time, and that patently has not happened. The exchange of notes with the US has been rolled over. The time limits imposed by the General Assembly resolution have not been complied with, and that is the position.
Well, my question was, actually, that wasn't the primary question.
Anything formal?
It was, well, I wanted to know if there was anything formal, because if there were, I would have thought it would be quite important that we actually know that there is something quite formal.
My Lord, can I double check? I don't think I've seen anything by way of a formal statement.
But what I was going to ask was, what is if you're correct in your analysis on this point, by reference to Lord Atkin, we haven't actually seen what he said, but you've given us the reference, what is the position of the English courts pending any response one way or the other by the government? So if we take, you're going to come to Article 56, but what would be the position if there is a rule of this intermediate kind that we're talking about, and other states on the Erga omnes basis would apply Article 56 in the way for which the appellants contend? Let's suppose that, because it is Erga omnes. What position is the English court to take? Is it just to hold up its hands and say, well, we can't say yes and we can't say no because we don't know what the government's going to say?
Well, my Lord, the position that the court should take is to recognise that there are constitutional restraints to the reception of a rule of customary international law into our law, and that those are operative at the moment. And so if you go with Lord Atkin, you do not, as it were, take the advisory opinion and use it as a basis for interpreting Article 56 in a particular way, still less for imposing a different test under anxious scrutiny. Because that all sits on the international claim. I'm sorry.
Sorry. In Banco number 2, the House of Lords recognised that there was, to put it neutrally, an important right of abode, and they held that the exercise of the royal prerogative was reviewable, but on the facts they found that it was a perfectly lawful exercise, it was a rational exercise of executive decision making. Now, we have a common law doctrine of right of abode. Why doesn't, and it may lead nowhere, but why doesn't the common law allow itself to be at least shaped by international law in a context where the court is balancing a common law right against a legislative or an exercise of executive power? Because that's what the House of Lords and what the courts did in Banco number 2. They did balance the two. They found in favour of the government, of course, on rationality grounds.
The short and complete answer to that is the one that Lord Hoffman gave at paragraph 66, which is that precisely this argument was run in Banco number 2. It was said, on the basis of the same old General Assembly resolutions that were relied on the advisory opinion, you've got a rule of customary international law which chimes with the common law right of abode. That's thoroughly supportive of the position that the appellants in that case advocate. And Lord Hoffman roundly rejected that on the basis of the monist theory of domestic law, and said its customary international law doesn't make any difference. Now, all that's happened in the meantime is that the courts have reconsidered the filter through which customary international might or might not come into domestic law. But none of that comes with any alteration to the principal thinking of Lord Hoffman, and it all comes with the caveat attached that there are constitutional constraints that need to be respected, including in particular legislation having entered the field, including in particular as another constitutional constraint, that it is for the executive to determine and implement foreign policy, including reactions to recommendations from the General Assembly, advisory opinions and everything else.
Sir James, can I just ask one further question on this point about shaping the common law? Accepting all those constitutional restraints, one of the appellant's arguments is, well, all this goes to show the fundamental importance of the right which was being considered when the executive made its decision. And what's the answer about the principled use of the advisory opinion in that respect?
My Lord, I think the crispest answer to that is the one that I gave in my first 2 points when dealing with customary international law and analysing the advisory opinion, which is that they were not dealing with the right that is now being asserted. They were not dealing with the rights of all Chagosians to reside in BIOT. They were dealing with a very specific issue, a very specific principle of customary international law to do with decolonisation, in the sense of BIOT being split away from the holder of the right, if you will, in Mauritius. I made all the points I made about the nature of the right of abode. I'm not going to go back on those, because I'm very keen to get to the ECHR sooner rather than later. But that's the short answer that I give to my. Well, the final thing I want to say in relation to this, before a couple of brief submissions on anxious scrutiny, is that there is at the very least a tension, we submit, and possibly a great deal more than that, between the ICJ opinion and the arbitral award. There is an arbitral award which you've seen reference to, which I haven't got time to go through now, but it was set up and constituted under Annex 7 of the UN Convention on the Law of the Sea in the dispute specifically between the UK and Mauritius. It's at Supplementary Authorities, tab 54, page 2908. Again, I don't have time to go through it now, but there was a clear recognition there of the truth of this dispute between Mauritius and the United Kingdom, which is that they had years been locked in an argument about sovereignty. This was a bilateral dispute. It was put to a UN resolution with the consent of both parties. I think it was binding. They made specific findings in this binding legal framework, including, see paragraphs 448 and 547, brackets B, brackets 2, that the UK is legally bound by its undertaking to return the Chagos archipelago to Mauritius when no longer needed for defence purposes. So you've got a binding ruling in an arbitration set up under UN mechanisms that those are the legal obligations as they inure between the two states. The advisory opinion says, well, the issues are all a bit different. See paragraph 81 of the advisory opinion. And no doubt they are. But one needs to be jolly careful with that difference, because the further you get into the consequences, in particular, of the advisory opinion, the more indistinguishable the two seem to become. And what that gives rise to in this context about constitutional constraints is you can't just look at the ICJ advisory opinion on its own. On the international legal plane, you have an advisory opinion of that kind, dealing with a very specific issue about colonisation, as I've indicated, leading to recommendations by the General Assembly in the blue corner, but in the red corner, under the same UN auspices for dispute resolution, in a bilateral dispute between Mauritius and the United Kingdom, you've got specific binding findings that have been made. So the position is far from uncomplicated, is perhaps the lowest way to put it. I'll also then briefly, to sum up on anxious scrutiny, the right of abode and the ICJ advisory opinion and its relevance to anxious scrutiny, 4 short submissions on that, if I may, and then I'm going to come to the ECHR. First of all, the ICJ opinion postdates the decisions under challenge, made in 2016, as you know, And you can't, for that reason, bring it in play to support a rationality challenge to a decision that happened before it was even promulgated. And in any event, Ms. Kaufman accepted that anxious scrutiny by the court would be likely to take into account the evident position of the United Kingdom government on the advisory opinion, which we've covered. And secondly, it does take one into territory of international relations and one voice for the reasons I've given. Thirdly, there is no correspondence between the rights, obligations and issues which the advisory opinion was dealing with and the right which is asserted in these proceedings as the basis for an anxious scrutiny argument, namely right of abode. And fourthly, it neither creates nor supports the existence of, or still less a breach of, any direct domestic legal obligation if it's said that CIL has become a part of domestic law. That's what I said about anxious scrutiny. I was going to turn to the ECHR if I may.
Certainly, yes.
And I start with jurisdiction. The starting point of my first submission is that there are, we make 4 submissions on the jurisdiction. The first one is that there is binding domestic authority at the highest level against the appellants. That doesn't need much exposition. See the judgment at 132 to 135. As the Divisional Court there noted, the House of Lords had held, as they did, in Bonku number 2, that the HRA did not extend to BIOT. And that was for the reasons given by Lord Hoffman at paragraphs 64 to 65.
That's about Article 56.
That's about Article 56. It is. It is. Those are the paragraphs 64 and 65. I wasn't going to add them unless you wanted me to. For good measure, quark fishing in the House of Lords before it went to Strasbourg is also against the appellants on this point. I'll just give you a series of paragraphs because that happened before Bonku number 2 and was relied on in it. Paragraphs 24, 39, 59 to 60, and 89, brackets last sentence. And quark fishing is in the Supplementary Authorities Bundle, tab 14, page 631 and following. Thirdly, in terms of decisions at the highest level, Bashir, which concerned the sovereign base areas on Cyprus, raised a similar sort of issue in relation to Cypriot declarations under article, or an equivalent article under the Refugee Convention. And a direct attempt was made to overturn Lord Hoffman, paras 64 and 65 in Bonku number 2, and was rejected by the Supreme Court. See in particular paragraphs 66 to 69 in Bashir, Supreme Court, Core Authorities, tab 22, page 850 at 871. And so the short point is that following Kerr and Lambeth, the Divisional Court was bound, and this court is bound to follow the precedent of the House of Lords and the Supreme Court, found at 137. The second submission on jurisdiction is that the European Court of Human Rights jurisprudence on Article 1 provides no driver for domestic change on Article 56, by domestic change from that position in Lord Hoffman 64 and 65. Still less any support for this court treating itself as unbound by that precedent. As the court put it at 138, there is no later inconsistent decision from the ECHR. That's inconsistent with the House of Lords in Bonku number 2. And the starting point, if you go to Bundle of Authorities number 2, is quark fishing and the United Kingdom. Page 1225 in the electronic. Jaffet 1227 and 1228. And the passage on which we particularly rely is the passage just by the second hole punch. This effective control principle, and I note that that was an effective control principle which is one of the bases for jurisdiction under Article 1 that had been recognised in Bankovich, which was about one television station in Belgrade, as you'll recall. The sentence after that by the second hole punch, this effective control principle of recent identification does not, however, replace the system of declarations which the contracting states decided when drafting the convention to apply to overseas territories for whose international relations they were responsible. And then a sentence or two on, the situations which it covers are clearly separate and distinct from the circumstances where a contracting state has not, through a declaration under Article 56, former Article 63, extended the Convention or any of its protocols to an overseas territory for whose international relations it is responsible. And bear in mind that the relevant islands here, the South Georgia and South Sandwich Islands, had been the subject of an Article 56/63 declaration. And Article 1 of Protocol 1 had not been extended. There had been a separate one when they signed up to that additional part of the Convention. So they are intended to be mutually exclusive, as that passage indicates. And it's no answer to say, as was tried in that case, see the bottom of the page, that this is all an outdated relic from colonial times. See pages 1227 at the bottom over the page. So then my learned friend says, well, Alskany makes all the difference. Go to the next tab 30 at page 1229. Again, Alskany will be very familiar to you. The submission is that the arguments and findings on Article 56 don't help my learned friend. You'll recall that following the argument and findings in the House of Lords in Alskany, the government ran the argument in Strasbourg. In this way, there was an attempt to use Article 56 to extend the logic of Article 56 well beyond the dependent territories that limit extraterritorial jurisdiction more generally. That was the nature of the argument on 56 that was rejected by the court. And you see that in the argument of 111 on page 1279 at the bottom. The House of Lords have been looking over my shoulder, they'd have said plagiarism at that point. But that was the argument that was rejected. But you'll see its nature. And 140 is then the key paragraph for present purposes on page 1289. See in particular the passage at the beginning of 140, the effective control principle of jurisdiction set out above does not replace the system of declarations under Article 56, formerly Art 63, which states decided when drafting the convention to apply to territories and so on. And then you have the rest of the paragraph. Which my learned friend took you to. So they're simply saying you can't use 56 and effective control of the area as a basis for jurisdiction where Article 56 is not in play. And obviously we didn't have the ability to make any Article 56 declaration in relation to Iraq. But you need a little bit of care with Alskany as well. I mean, I know my learned friend was pressed for time, but the way in which Alskany does develop the various bases of jurisdiction needs to be quite carefully borne in mind. What they effectively did in Alskany was to say, we are sticking with ECA as a concept, that's effective control of an area as a concept, as a basis for jurisdiction. And that's the stuff of 140. But then they considered there was another basis for jurisdiction, state agent authority and control. So that if, for example, someone is in the custody of British servicemen abroad, they are within the jurisdiction. And the argument that was there run, again faithfully with the House of Lords in Alscanis over here, was, well, hang on a second, how can you guarantee all of the rights under the convention in circumstances in which you're in somewhere like Iraq and you don't have the ability to have fair and free elections and so on? Well, the answer to that was they then did a split. If you look, if you're still on page 1289, if you look at para 138, third last line, you will see that if you're dealing with the effective control of the area as a basis of jurisdiction, then what has to be done by the contracting state is to guarantee the entire range of substantive rights. You see that in the pre-penultimate line of 138. So if you're effective control of the area, you've got to do everything. The earlier passages, when they were dealing with state agent authority and control, under the different heading that starts above 133, they did allow for what they called dividing and tailoring. So that if, for example, you're a soldier and someone is in your custody in Iraq, you don't have to, that doesn't trigger an obligation on the UK to organise free and fair elections or pay them social security, but it does mean that you can't breach their Article 3 rights. That's what they meant by dividing and tailoring. And it was only in that sense that Bangladesh was overruled. But on no view did we have that sort of responsibility in Iraq, so it's hardly surprising I thought that the Article 56 argument went as it did in that case. It doesn't tell you anything about what should be the position. If you are in a place, it's an accusation that you are at the very least de facto responsible, so that you can give an Article 56 declaration. And that was the issue that was confronted in Chagos Islanders in the next tab, tab 31.
Well, before you go on, I just want to, you've covered a lot of ground on Alscani, and I would like you just to summarise, please, the two, in separate points, very briefly, the points that you're making on the decision in that case, because you've been quite discursive, if I may say so, about it. Can you just encapsulate in 2 or 3 bullet points what you say we get or we don't get from Alscani?
Well, I can try. 1. What the court did in relation to all bases of jurisdiction other than effective control of the area was to say there is a principle of state agent authority and control. So you can bring someone within the jurisdiction of the United Kingdom if they are under one of your agents' authority and control, e.g. the prisoner in Iraq. In that context, the rights under the convention can be divided and tailored. So you only have to afford the relevant rights. 2, in relation to effective control of the area, dealt with at 138 to 140, a different principle applies. If you are in effective control of the area, as that concept is defined, you have to afford the entire range of substantive rights. See 138. 3. Paragraph 140 starts effectively with a recognition of the reasoning of the court in Quark. And for the remainder of it, 4, that's the remainder of 144, it's simply saying you can't use Article 56 to reverse engineer a general position under which there is no extraterritorial jurisdiction. Well, would you give me just 1 moment? I'm just going to shut a window and someone's making a noise outside.
Yes, certainly. Thank you.
I was going to go to Chagos Islanders itself. Next tab, tab 31. Analysed correctly by the Divisional Court at 138 to 142. And if you would go in the judgment to paragraph 67, you will see they there start to deal with jurisdiction under Article 1. And it's obviously of some real importance how they go about analysing the jurisdictional issues. And it is to be noted in that respect, it is to be noted that they considered specifically the Abscania argument and what decided at paragraph 70.
Do you have the page number? Sorry.
Sorry, 1324, my lord. Rejected the argument from the appellants, and they were all the same appellants as you've got here, the applicants there. They reject the argument that they fell within the jurisdiction, upholding the reasoning in Quark, particularly 73 to 75 and 6. See that although they don't finally decide it, the seeds of the destruction for the argument are in the final sentence of paragraph 75. So, in a nutshell, the core of any jurisdictional argument in relation to like Loisidu, is that you are fulfilling governmental functions and you've got effective control of the area. And of course, that's a position that applies by definition in the context of colonies. But for that situation, Article 56 would be effectively entirely undermined because you'd always have jurisdiction on that basis, either through the governmental functions limb or through the effective control of the area. And that can't possibly have been the intention when the states signed up to the convention. And of course it isn't a function of whether you're self-governing or not. South Sandwich in the Quark fishing case was not. Lord Bingham noted at paragraphs 2 to 4 in supplemental bundles, tab 14, page 639. So we respectfully submit that there's a clear decision on jurisdiction in Chagos, and we are not therefore in the Kay and Lambeth game. And I would add, particularly given the caution that is to be applied when these courts, and indeed the court in Strasbourg, come to consider base jurisdictional questions of interpretation, where they are peculiarly and particularly cautious, recognising the foundational nature of those provisions. And I want to give you just one reference without inviting you again to turn it up on that. It's the paragraph before the paragraphs, my lord, that Mr. Jaffe took you to in the Smith case, para 44 in Lord Hope of Smith, supplemental authorities, tab 20, page 909. So this isn't a case, we submit, where we are in the K game. We are not. This is not a case where the Supreme Court has expressed itself to be remotely interested in disagreeing with the Lord Hoffman analysis of 64 to 65 of Bonku number 2, as we know, because that was directly tried in Bashir and was rejected. So that's the second point under jurisdiction. But the ECHR jurisprudence provides no support for disagreeing with the House of Lords in Bonku. Can I then turn as the third limb to Article 56 itself? And I wanted to make 6 submissions in relation to Article 56 itself. Starting from the position that we're all agreed that the Vienna Convention on the Law of Treaties, for authorities, tab 7, page 68, Article 31 of the VCTL sets the rules of interpretation of an international agreement of this kind, a convention of this kind. And again, as you're all aware, that breaks down into primary rules of interpretation and subsidiary rules. One of the subsidiary rules is the one that my learned friend took you to, about international law in 31.3. The primary rule is that conventions have got to be interpreted, quote, in good faith, in accordance with the ordinary meaning to be given to its terms in the context in which it sits and in the light of its object and purpose. So it's against that backdrop that I come to make the 6 submissions. And the first of them is that we are here dealing with a base provision. It's foundational in the sense that it's the gateway to the convention rights and the need to secure them. But it's also a base provision in time. It had a meaning when it was first signed up to. It was the basis on which states agreed to sign up. We re-looked at the Travo for the purpose of seeing whether assistance could be derived from the Travo. And again, in the usual way, they're pulling together a whole bunch of disparate things. We sent you a version of the Travo, which I hope you would have received by email. I'm not going to go through it in any detail, just to clarify what it is. This is a summary, evidently drawn together by some diligent member of staff in the Council of Europe in 1978. That's the date on the top of the first page of it. It's the thing said and done in 1950. So just to be clear that that's don't get confused by the dates. But the things that we respectfully take from that document, even if on a cursory glance through it, are that they were here dealing when it went through the different numbers, when it became 63. They were designed to deal with colonies. This provision was designed to deal with colonies.
I'm not certain you need the Travo for that, because that is, I think, expressly referred to in at least 2, possibly 3 of the judgments of the court. But it is.
It was certainly referred to in Alscania at 140.
And I think it might have been, I think possibly in Quark as well. But I mean that's the only references, and I think Lord Hoffman referred to it in Banker number 2. It is about colonies. I mean, that's the only references you get in any of the case law. It's about the historical position of colonies and conferring the right on contracting states to extend the convention rights to their colonies, with the implicit assumption that we're dealing with colonies that are lawful at the time.
Well, at the time, certainly, but it is to do with colonies. It's called the Colonial Clause, and it applied in the Refugee Convention, as you see from Bashir, and just in a very similar way. So it is a colonial court, and it's evident from the Travo there were real sensitivities as a result of the fact that member states had colonies of various kinds, and they were treated in different ways by different member states. And to deal with that state of affairs, colonies were a fact. There was no question of colonies being unlawful or rights of self-determination of peoples rendering anything unlawful. Article 63 was precisely there to deal with how member states should and could deal with an ECHR extension. That's why it's commonly called the Colonial Clause. That's why we call that in the Travo. And it confirms that the real question they were debating before this got signed up to was the question of discretionary versus mandatory extension to non-metropolitan areas. And that was highly controversial. That was the key debate. That was the row that occurred in relation to this clause. And the UK preferred discretionary and ultimately prevailed. And it became Article 63. So you're not dealing with military occupation or anything of that kind, but with colonies, however acquired. And some of them were by cession, as ours was in relation to BIOT, by cession from France. Others were acquired by conquest. Others were acquired in different ways, which nowadays would be regarded as anathema. Doesn't matter. They were colonies, and this clause was designed to deal with colonies, however acquired. And as I say, the key debate was between mandatory and discretion. And so Loisidu, cases like that are nothing to the point. It's not a colony. Couldn't go in now and invade a territory, take it over. That was the reasoning in Al-Scain, bits of Iraq. So if the question was asked the day after this was signed up to, as it should be, because this is a question of interpretation, it must have had a meaning then, whether it could be used to extend the ECHR to any and all UK colonies in 1950, you get a very clear answer indeed. And that answer does not depend upon establishing in international law the lawfulness of the holding, the lawfulness of the cession by Napoleon, the lawfulness of the invasion a century earlier of some other colony. So that's the first point related to the Travo. Secondly, we submit, as a matter of interpretation, it's entirely implausible to insert the word lawful into Article 56/63. It's entirely implausible as an imputation of state intention in 1950, or even subsequently. No doubt a member state signing up to Article 63 acquired colonies in different ways, and no doubt by modern standards, everyone would have a lot to say about some of the ways in which they were acquired. My learned friend Miss Kaufman asserted that all colonies have and had a right to self-determination, but if that's so, and that's all unlawful, therefore, it's impossible to see how this clause had any application from the off. How could that have been the intention? So that's the first point on implausibility of imputation of intention. The second sub-point on that is that Article 63 was plainly not designed to raise a series of points of enormous controversy and difficulty for member states. Are you lawfully responsible? Easily stated, massively difficult, massively controversial when dealing particularly with, or inter alia, with the sort of historical issues you were asking me about earlier. It was designed rather to cover colonies, to deal with the mandatory versus discretionary issue, and not to include or drag in its wake the need for someone to determine those sorts of issues of lawful responsibility. Who would judge it? Would it be the ECHR expected to examine and rule on that? Is that what states were doing? That would be an amazing conclusion. The ICJ wouldn't have jurisdiction to rule on it unless the matter was referred by agreement between the two states. And in practical terms, what level of lawfulness is required? It's just a recipe for uncertainty, we submit. So that's the second point. The third point is that, unsurprisingly, as a matter of textual analysis, there's nothing in the ordinary meaning of the terms of Article 56, interpreted in good faith in accordance with the language used, that imports this lawful component into responsibility for international relations. That could easily have been said, and if someone had tried to insert that word, one can imagine, given the scale of debate illustrated by the Travo, even on mandatory versus discretionary, what the reaction would have been, with a clause specifically designed to deal with colonies. Fourthly, there is nothing in any case law or anywhere else supporting an interpretation that responsible includes or imports a concept or a precondition of lawfulness as a matter of public international law.
Your submission necessarily involves the proposition that if the occupation becomes unlawful, which is the appellant's position, that you're still entitled to treat it as a colony for the purpose of Article 56 in a convention that is, I know you referred to it as being interpreted as on the date of its conception, but it's a speaking convention. It can evolve.
Well, you need to be jolly careful with that. It's a living instrument convention in relation to the substantive rights which can develop in accordance with developing mores. But it's far more controversial to work out whether or not these jurisdictional provisions attract anything like the same approach. That was why I referred you to para 44 of Smith, and that's why I refer you back to Bankovich. One needs to be jolly careful with that proposition, if I may.
Your analysis still involves the proposition, and I'm putting it in extreme terms. I'm not necessarily saying it applies to this case, but an occupation that becomes unlawful and in contravention of international law, still under the European Convention on Human Rights is treated as a colony.
My lord, it is still treated as a colony for the purpose of Article 56, in the sense that it will be open to the state to extend the ECHR to it and to those citizens pursuant to the de facto continuing administration that it did.
So we're in de facto administration, which does smell a bit more like Article 1 than Article 56. This is the argument put against you. Once it's an unlawful occupation, and again I'm using extreme language just to make the point, it does sound a bit more like Article 1 than Article 56.
It isn't, because what we're doing is construing the reach of Article 56. What we're doing is to construe whether or not you should imply the word lawful, with all the controversies attached to that, into the power that is given to states which hold in that way to extend the convention or not.
I understand.
And that was the fifth point. I mean, one can flip that argument around in one way, but by looking to the beneficial effects of it. Because you've got potentially beneficial effects. Its purpose is fundamentally benign. It is to allow the states to extend those obligations. And it's not probable that member states wanted to prevent a member state from exercising that right and extending, even if it was purporting to be responsible, de facto. And sixthly, the case law tends to confirm this by focusing on Article 56 as essentially discretionary, and without any suggestion of examination or the need to determine international lawfulness as a precondition to the basic application of Article 56. Go back, if you would, to Chagos Islands, if you still have it open, marvellous. Tab 31, and I want paragraph 48 for this purpose. This is a summary of the argument of the applicants. They included arguments that there were, look at the penultimate sentence about 3/4 of the way down. They argued further that the BIOT was unlawfully excised from Mauritius, which did not recognise UK sovereignty, involved protest with the UN. 56 was not applicable as part of Mauritius under international law. Further alternative form Parliament and so on. You've got arguments that 56 can't be invoked by the UK because of alleged illegality under public international law as a result of the so-called excision of the Chagos Islands from Mauritius.
Can I, James, can I try to understand how you're interpreting these words, it is responsible? You said a lot about what it doesn't mean. It doesn't mean lawful, and you've given a whole series of reasons why there isn't an implication of lawfulness, beginning with the controversial aspects and looking back historically and the difficulties. Is what your argument comes to quite simply reduced to this? That, I'm not saying it's right or wrong, I just want to make sure that I understand, that the words "it is responsible" should be read as meaning for which it has assumed responsibility.
One can do it in that way, my lord, yes. I use the phrase de facto, but matters not how you do it.
But at least that leads, without introducing any Latin, if we can avoid it, that at least has the benefit of, I think, using English and as an interpretation of the words "it is responsible." All right.
Yes. Or even you don't insert those words and you just look at it at, if you will, starting at 1950, and you say, well, who has colonies at that stage?
Well, I mean, I'm trying to look at the actual words of Article 56. So, I mean, you're putting in colonies as part of the background. I mean, Article 56 itself simply talks about the territories for whose international relations it is responsible. And at the moment, it seems to me what you're saying is you're looking at a factual position as opposed to any kind of legal gloss or legal assessment. And you're simply saying it's the territories for whose international relations it has assumed responsibility as a matter of fact.
Yes, the alternative I was putting rather badly is it goes with is responsible. Whose territory it is responsible. And you test that by reference to whether it is responsible for them in 1950. And there comes a point pretty shortly after 1950 at which no further colonies are being grabbed. And if they are,
right. So are you? I see. Okay, so that's a slightly different point. So you're saying that you're in that because I'm not sure we've had any new colonies. There may have been some, but I would doubt whether there's been any new colonies by members of the Council of Europe since 1950, and I may be wrong about that. You would say extend to all or any of the territories for whose international relations it was responsible as colonies in 1950.
Yeah.
Yes.
And so if you look at this in 1950, the present tense makes sense. It is responsible. And the reason it's responsible, that's why I introduced the confusing colonial thing, but that's from the Travo. It is responsible because at that stage it was a colony. So you could do it in either or both of those ways.
If the facts of Al-Scani had occurred prior to 1950, would Iraq have fallen within Article 56 vis-a-vis the United Kingdom? Because we would have been responsible for its international relations.
Well, I'm not sure. You might or might not have been. I'm not sure that being in a state of occupation does render you responsible in that way. And there might have been a pretty live question around whether or not being an occupying power for the purposes of that they were dealing with in Iraq would necessarily bring that consequence with it.
So that rather, I'm not saying if that doesn't undermine your argument, because it rather suggests mere occupation or mere effective control is not enough. There's an element of legality attached to it as well.
Well, it's a question of whether or not you are responsible for all the international relations of the body.
All right, that's fine.
My lord, I was back on Chagos Islanders, if I may,
Yes, certainly.
and I showed you the nature of the argument, including a similar argument to the one run in front of the ICJ at 48. PA's on page 1319. Did not touch the reason of the court. They didn't assume that there was lawful administration. They were confronted by an argument to directly the opposite effect. But they found that none of that constituted any basis for ignoring the scope and application of Article 56. See paras 74 to 75.
Yes.
So that's the position in relation to the case law in relation to Article 56 and the submissions, the 6 submissions I make on Article 56 itself. The fourth submission I make is that the advisory opinion has no bearing on that ECHR case law on jurisdiction. You can't use international law to override the primary rule of interpretation and the clear wording and intent base of Article 56 is a submission. And I've made my submissions about the advisory opinion. It's advisory and not binding. It addresses what it addresses, no more, no less, to which one can add, and the sort of arguments that were being deployed there and the subject of the court's opinion were also deployed in Chagos Islanders without any effect. And its findings do not bear anyway on Article 56 and the question of responsibility under that convention. On the contrary, it might be thought the ICJ opinion recognises, at the very least, that the UK is in fact exercising sovereignty over the BIOT. See para 177 of the advisory opinion. Not in lawful occupation of the territory, at most as a non-binding resolution of the General Assembly to complete the process of decolonisation.
You haven't expressly, I think, imported into this part of your analysis the distinction between peremptory norm and CIL. Is that anything? Does that have any bearing upon this issue of interpretation?
That was my next point on the advisory opinion.
Ah, okay.
My lord, the case that I'm having to meet, the case that I was meeting, which is why I spent a bit of time at the outset of this afternoon to dealing with that, is that there's a non-recognition principle. I've shown you that that flows only if there's a finding of a peremptory norm, Article 40, Article 41 of the ILC articles. And we're not here dealing with a non-recognition principle, which appears to be the foundation for the suggestion that this can be in some way dragged in. So all you're left with is a non-peremptory, without therefore the consequence of an obligation of non-recognition, erga omnes obligation opined on by the ICJ, and no more than that. And none of that touches the question of whether the state is responsible, or if I'm ready to look at it in 1950, whether it was responsible for the colony then.
Just on this point, erga omnes. Obviously, erga omnes. The omnes are all the members of the General Assembly. Does erga omnes apply to anybody outside that? I'm assuming there are some people who are outside the General Assembly.
I think it's not restricted necessarily to General Assembly. It's a general principle of international law.
Right.
So it can apply to others.
Thank you.
But the core point in my submission you have, which is that this doesn't bring with it the non-recognition right, which was the foundation.
Yes.
For the argument, which would have an impact on how you go about interpreting Article 56.
Yes. Thank you.
That's why I spent a bit of time on it. This afternoon. And finally, in relation to this, the fact that Western Sahara, do you remember that was the CJU case that my learned friend took you to, Core Authorities, tab 34, page 1586. The fact that advisory opinions are referred to in the Western Sahara case takes one no further, for the simple reason that the EU law is not here in play. No one suggests that the resettlement decision falls within the scope of EU law. And on the recognition of PIL in Western Sahara was through the provisions of the TEU and the TFEU, in particular Article 3 sub 5 of the TEU. See paras 32 and 47 of the European Court's decision in that case. So we respectfully submit that for all of those reasons, the ICJ opinion takes one no further in relation to the Article 56 issue, certainly does not undercut the clear reasoning from Strasbourg and doesn't bear in any sensible way on the interpretation of it for all the reasons I've given. The next topic then beyond jurisdiction is victim status, which is a complete and freestanding answer to the ECHR claims anyway. Victim status for the purpose of Section 7 of the HRA is explicitly tied to Article 34 of the ECHR. And on victim status, I make three submissions. First, the Article 34 ECHR provision ties in the concept of victim status with a natural or legal person who lodges an application complaining of a violation of the ECHR. But the European Court in Chagos, if you still have that decision to hand, go back to paragraph 61 to 62. On page 1322, where they rely on the fact that the right of individual petition has not been extended to the BIOT. And the complaint in that case was ruled inadmissible in part on that basis. So the judgment of paragraph 145 is right. And you'll note that Article 34, which is tied into Section 7 of the HRA, is headed individual applications. And it describes a victim as being a victim by one of the high contracting parties of the rights set forth in the Convention. Where they haven't extended those rights, there can't be a violation of that kind. So that's the first point. The second point is that neither of the appellants are victims anyway, and thus do not have standing to bring the proceedings pursuant to Section 7.3 of the Human Rights Act. And in that respect, we submit the judgment at 145 to 147 was right. That question was settled entirely and conclusively by paragraphs 77 to 83, all of which need to be read, I respectfully submit.
Sorry, 77 to 77 to 83 of what? Of the Divisional Court?
No, of the Chagos Islands.
Chagos, okay. Right.
Sorry, I'm still behind tab 31 of the
Yes.
second authorities bundle, page 1325. 77 is at the bottom of 1325.
Thank you.
You'll see how they do it. I mean, on page 1325 going on to 1326, it's all about the settlement. They note that at the end of 79, para 79, of particular relevance, the fact that Chagos Islands are represented by lawyers and the litigation is settled. Then they deal with the position of islanders who weren't part of that settlement and hadn't made claims. Look at the final sentence of paragraph 80. Then they cite the very well established principle that if you take money for the breach, you're no longer a victim. Paragraph 81, first few lines, culminating in the citation of Karaha and the United Kingdom. And then the remainder of that paragraph, they deal both with the position of those who were claimants and were parties to the settlement, and see the final sentence those who weren't.
Does that deal with the Seychelles Chagosians?
It does. It deals with both lots. And you'll remember that the lady here, the appellant, who was the Seychelles, represented by Mr. Jaffe, she was an applicant in Strasbourg. All people who were appellants in this appeal were applicants in Strasbourg.
Paragraph 53 refers specifically to the Seychelles.
It does. And you will see in particular in paragraph 82 that they ran there as they've run in this appeal. We've got other categories of people, those who aren't born on the islands, never had a home. They couldn't claim to have victim status, as the court found. Then they ran continuing unjustified interference. It was a continuing breach. That was rejected in 82. And then the remainder of 82 is basically Lord Hoffman in Strasbourg. I'm allowed to summarise it in that way. I'm probably not by the look of Lord Justice Dingemans' face, but you get the point. The remainder of 82 is very, very closely related to the paragraphs I kept going back to, paragraphs 53 and following in Lord Hoffman's judgment in Bonku 2. And you'll note in particular at the back end of 82 that the court is there dealing with interference. Look at the last sentence or two of 82 on page 1327. These circumstances, the court finds the 2004 ordinance cannot be said to have amounted to an interference with the right to respect for their homes. It is apparent from the judgments given that whatever the outcome of the proceedings, they continue to have no legal or practical prospect and so on. Not persuaded that anything recent has altered any of that. But you'll bear in mind that this was a challenge in Strasbourg primarily to Mr. Justice Ousley, who effectively said, well, no, that's it. You've taken the competition, that's the end of it. And in relation to the Seychelles Chagosians, which my Lord Master of the Rolls raised, Mr. Justice Ousley found that they could have found out about the litigation and taken part, but hadn't done. That's his judgment at paragraphs 684 to 685 and 731 to 735. And his judgment is in supplemental tab 12, page 284 and following. And you'll note, my Lord Justice Dingemans was ahead of me, but there are other references in Chagos that may be relevant on that point. See paragraph 19. The penultimate sentence, summarising Mr. Justice Ousley, he also found the Seychelles Chagosians knew the same relevant facts at the same time as their counterparts in Mauritius. See that record in the final, third last sentence in paragraph 19. Then Her Majesty's submissions, Her Majesty's government's submissions at 43. See the second sentence. Again, Seychelles Chagosians. And their submissions, that's the other side submissions, including the Seychelles Chagosians, at 53 on victim status. So you can see what arguments were rejected. 53 on page 1320. You go into victim analysis, and that analysis is untouched. It was centrally based on the settlement of the claims and the non-pursuit of them even though known. It specifically rejected the attempt to escape from that by saying a continuing obligation as a result of the prohibition on the term. And they found, as you see, Mr. Jaffe's only answer to that was to say there's now some possibility of return as a result of the ICJ advisory opinion. But that doesn't affect victim status. It doesn't affect the reasoning of the European Court one iota. They weren't victims because of the settlement. They're not made victims by the advisory opinion, simply incoherent. So that leaves only engagement. So far as Article 8 is concerned, and interference with Article 8, well, you saw the reasoning in the Chagos Islanders case. the broad point is that in assessing whether or not there's been an interference with Article 8, that's a lack of respect shown to private rights and home and so on. The broad point is that events have moved on in all the ways identified by Lord Hoffman and since. And the interference, the failure to respect issues, fall to be assessed in the light of all those circumstances, including, see Lord Hoffman and see the equivalent paragraph in the judgment of the European Court in 82, the length of time, the fact that no one returned when the changes were made to the 2000 order, between then and 2004, no one returned, the fact that compensation was paid, the fact that there is no obligation to confer a right of abode on Coup 2, the fact that there is no obligation to fund resettlement. And you see the basis on which both Mr. Justice Ousley rejected attempts to resurrect that and the impact that that had on Strasbourg in relation to both victim status and interference, which tellingly are, as it were, put together in part in paragraph 82. That's the backdrop for Chagos 82, including the claim that was rejected of continuing breach. So then they contend that there's a right to abode decision which violates Article 8, but the same answers apply. That would just as much fall foul of the victim status concerns in Strasbourg and of the interference analysis in Strasbourg. But it's to be borne in mind that the challenge is to the 2015 decision. Rights in 1972 are long gone, can't be resurrected in that way. They don't have a right to a home in the sense of any right of abode in the Chagos Islands within the meaning of Article 8 for the purposes of that resettlement decision. Their homes on the archipelago no longer exist. They've got no arguable claim to property rights, as Mr. Justice Ousley found in his litigation. And as Lord Bingham found in Care and Lambeth, paragraph 28, Core Authorities 15, page 358, Article 8 does not confer a right to a home where none exists. And nor, for good measure, does Article 8 confer a right on a person to enter a territory in order to establish a family unit. See all those immigration cases, including the requirement to have an English language test considered by the Supreme Court, EB, Supplementary Authorities, tab 23.
So can you give me the Lord Bingham reference
yes, my
again?
Lord, sorry, it's paragraph 28 in Care and Lambeth, and it's Court Authorities, tab 15, at page 358.
Thank you very much.
So the two cases my learned friend relied on in Article 8, Sargassan, tab 33 of the Core Bundle, and Chiragoth, tab 32, simply don't touch any of those points. They're simply non-comparable on the facts, given the developments. And the case that truly does show you the way, both in relation to interference and victim status, is the case directly on point, which is Chagos. And so the same points, and finally, the same points apply effectively in relation to interference with property rights under A1B1. First of all, quark fishing. Providing a complete answer in relation to all of that. Even if the first protocol had been extended, as it were, this engagement, Mr. Justice Ousley finds no arguable property rights or possessions. That was the core of his finding. And any property rights that they may have had have long since been extinguished. And we refer in particular to one Strasbourg authority in one paragraph called Stretch and the United Kingdom. And paragraph 32, Supplementary Authorities, tab 41, page 2156, where the court said the hope of recognition of the survival of an old property right, which it has long been impossible to exercise effectively, cannot be considered a possession within the meaning of Article 1, Protocol 1. So all the same points about developments over time and what has happened since, including settlement. apply equally to the idea that there's been any interference with possessions for the purpose of A1P1. My lords, those are my submissions.
Thank you. Any questions, Lord Justice Green? Any questions?
Just one. We're still left without the United Kingdom's formal position in relation to the United Kingdom. As I've understood it, the United Kingdom, and we will have to obviously try and record this at some stage. I think it would be very helpful if we actually had either on instructions from your formal position.
Yes. My lord, I think the position is, I was informed in the 5-minute break while I was dashing out for a breath of air and the phone rang, that there was a ministerial statement at the time, I think by Alan Duncan. Can we make sure that we give you the totality of whatever public statements there have been and put that on an email? I think rather than my trying to describe it now, that might be a more satisfactory way of doing that, if that's acceptable to the court.
So we would have something that we can record in the judgment which is safe.
Exactly so. Exactly so. And I'll restrict it to statements that have been made publicly.
Right, thank you very much.
Lord Justice Dingemans.
I have no questions, thank you.
No, thank you very much, Sir James. Now, who is speaking first? Mr. Jaffe?
Yes, my lords, can you see me and hear me, hopefully?
I can now see you. Now, look, how are we going to deal with the time? It's a Friday evening. I'm actually very reluctant to go beyond 4:30. We can go to 4:30. Will you be able to divide it up between yourself and Ms. Kaufman?
20 minutes each.
20 minutes each. Very good. Thank you.
My lords, just on the point that Sir James just raised, there was a written ministerial statement after the advisory opinion, and what said on behalf of the United Kingdom is that they respect the decision of the International Court of Justice, but the United Kingdom doesn't agree with it. And of course, the United Kingdom voted against the resolution at the General Assembly, and its position, which is said publicly, and again we'll make sure that the court has all public statements, is that the advisory opinion and the General Assembly resolution don't create any legal obligation. So consistent with what Sir James has told the court. Can I deal, if I may, with the advisory opinion, first of all? As I've just said, the advisory opinion and the General Assembly resolution have to be looked at alongside each other, because together, and they do operate together, as they both expressly say, they form a persuasive and clear statement of the requirements of international law as they state it. And that's because, of course, they are both an authoritative judicial opinion following contested argument, the overwhelming acceptance of states in the General Assembly of the conclusions of the advisory opinion, and the view of states as to what must happen next. So together they actually form more than the sum of their parts, because they mutually complement and they reinforce each other. And that's because the General Assembly, in saying what should happen following the advisory opinion, is carrying out a task which the court has expressly said is for the General Assembly. And those are the provisions between about 175 and 180 of the judgment which you looked at with Sir James earlier. So the basic finding that was made in the advisory opinion is the obligation on the United Kingdom to bring to an end its administration of the archipelago as soon as possible. That's 178. Now, that is a basic and clear obligation of international law, which is being stated in the advisory opinion. Cease and desist in administering the territory. Now, the reason for that finding is the fundamental human right of self-determination. But actually, for the purposes of my jurisdiction argument, it doesn't actually matter what the reason for that finding was. That is the obligation in international law. And the UK's failure to comply with that is a breach of an obligation, Erga omnes, which is owed in respect to all states, of which concerns all states. And I'll mention what that means, if I may, in just a moment. Now, what's the relevance of the advisory opinion? Well, neither I nor Ms. Kaufman suggest it becomes a directly effective common law obligation. It may, of course, inform the development of common law, but my submission is to rely on it for the purpose of the convention. Because what is said against me by my learned friend is that the only route to jurisdiction under the convention is Article 56. And that's based on two propositions. The first proposition is that the United Kingdom is responsible for the international relations of the territory. That's proposition number 1, which he makes. That is, of course, the provision that defines the scope of Article 56. And the second proposition, which follows on from it, is that Article 56, where it is potentially available, is an exclusive route for the application of the Convention. And those are the two propositions that lie at the heart of the argument. Now, he repeatedly refers to it in terms of extending the scope of the Convention, but actually, of course, in reality, it's about avoiding the application of the Convention. And so, rather than being a provision which, as he very politely put it, was fundamentally benign, of course, it's actually a means of preventing human rights obligations from taking effect in relation to BIOT. And one must be honest about that. I understand why he put it that way, but that's the reality of it. So what we need to do to see if those propositions are good is to construe the words responsible for the international relations of the territory. Now, that wasn't debated in the Travo, I think we all agree about that. For what it's worth, the living instrument principle does apply to jurisdictional questions. That was decided by the Grand Chamber in Loiseau, which is page 1701 of the Core Bundle, paragraph 1701. The United Kingdom government has consistently argued that it does not, but that is not the view that's been expressed by the Grand Chamber. So what does it mean to be responsible for the international relations of a territory? Well, take the very simplest example of being responsible for the international relations of the territory. That would be to negotiate and to bind the territory to a treaty obligation. That's the most basic and fundamental obligation in international law. And of course, that is of itself what Article 56 is all about. Article 56 is all about applying the Convention, which is a treaty, to a particular territory. But what we know by reference to cases like Western Sahara is that the United Kingdom doesn't, in my submission, have the power to bind the British Indian Ocean Territory in international law any more than Morocco had the power to bind Western Sahara to treaty obligations with the EU. And in both cases, what was happening is that the treaty was being interpreted in such a way as to give effect to the international law limits on the powers of states rather than frustrate it, and to ensure that the international body in Western Sahara is the European Union, here it's the Council of Europe, from giving practical assistance and effectiveness to a continuing unlawful act in international law. So the UK just doesn't have the power to speak on behalf of the territory on the international plane for the same reason that Morocco doesn't speak for Western Sahara. The United Kingdom is not, in fact, responsible for the international relations of the territory, and any acts are no more than purported acts. The state that is responsible for the international relations of the territory is, of course, Mauritius, which is not a member of the Council of Europe. Still less is it sought to rely on Article 56. So the basic argument is that the UK couldn't make an Article 56 declaration even if it wants to. Of course, it doesn't, for obvious reasons. Article 56 is simply irrelevant in light of the analysis of the International Court of Justice and the General Assembly resolution. Now, my learned friend's response to that, and it is quite a bold argument, is that we should read the Convention as recognising and giving effect to the United Kingdom's de facto, as he put it, exercise of purported responsibility for the international relations of the territory. And for the purposes of this argument, he is accepting, without of course being the government's position, that the court thinks that the advisory opinion is right. So that requires the court to construe the advisory, to construe the Convention in the word responsible as including unlawful acts of no validity. And he supports that by saying that a special approach is to apply to this because it involves colonies which have historically may have been formed on all sorts of unlawful and inappropriate bases in international law. Now, the word colony appears nowhere in Article 56. That's the difficulty with that argument. Instead, the framers of the convention used a different formula. It doesn't say for any territory in which a contracting state has a colony. It says territory which a contracting state is responsible for the international relations law. And it's the word responsibility that's crucial in the matter of construction. And we know from Demir, and in fact the Secretary of State accepted in his submissions, that the drafters of the convention thought it was so obvious that the court would have to apply general principles of international law in interpreting the convention, that they just thought it was unnecessary to even say that, to introduce an express clause to that effect. So the consequences of my learned friend's logic are that the United Kingdom could have made an Article 56 declaration in respect of southern Iraq, where it was the occupying power, because it had de facto control of the territory. Unless we are to read in some special provision saying, well, maybe in relation to colonies which existed at the time of the convention. But that doesn't help them either, because of course BIOT was formed in 1965, 15 years after the conventions. So on the Secretary of State's logic, how are we to approach, for example, a more modern difficulty? Is there convention jurisdiction over Russian breaches of the convention which occurred in Crimea? Well, the Secretary of State says you look at who is de facto responsible for the international relations of the territory. Well, de facto, that's Russia. The tanks have rolled across the border. You ignore whether the occupation of the territory is completely uncalled for. And in those circumstances, it's Article 56 that provides the sole route to jurisdiction. The same applies to the same problem with the Turkish Republic and Northern Cyprus. The only thing we can get out of the Travaux Preparatoires is what the UK said was the purpose of Article 56, it was then Article 63, that was strongly promoted by the United Kingdom as being a very important provision. The only part that I would refer the court to, I don't invite you to turn it up now, is page 23, which is the speech by the UK representative explaining the purpose of the provision. And the purpose of the provision, so it said, was to promote self-determination, because it would be wrong in principle for London to bind a colonial government to the convention against that local government and local administration's will. So the reason that was put forward for this was the argument which I made in opening, the Gibraltar example, that if a local administration doesn't want to have the convention rights applied to it, then why should it? That assumes there is, of course, a meaningful local government. So that's the basic answer to the argument which is put forward by my learned friend. There are a bunch of additional points which I'll deal with very briefly if I may. So James makes much of the fact that the International Court of Justice is about the decolonisation of Mauritius and the resettlement of Mauritius. And indeed that's so, but that doesn't help him. It's the appellant's positive case that Mauritius is responsible for the international relations of the territory, not the UK. And rather than being a problem for my case, it's past case. Secondly, what he says is that there's some mismatch between the advisory opinion of the International Court of Justice and the human rights claim, because it's really for Mauritius that this is all right to carry out the resettlement of the territory and not the United Kingdom. Well, again, we agree what ought to happen is that the United Kingdom ought to cease its administration and it ought to return the territory to Mauritius. But I dare say that Mrs. Loisedu thought exactly the same. She thinks that the Turkish puppet administration in Northern Cyprus ought to close down and cease administering the territory. But for so long as the UK does administer the territory, then it has to deliver the convention rights, even though there is continuing unlawful administration. And it's no part of my case in this court to ask this court to make the British administration of the island cease. It's a pure matter of international law. The UK government has made its position clear. And it's certainly no part of the convention case to force the court, for the court to try and force the UK to do so. I simply say that it's relevant to the question of jurisdiction in the way that I sought to describe. Now, the next point my learned friend makes is about whether or not the right of self-determination is a peremptory law. A considerable reliance is placed on that. I make two responses. The first response is, so what? It doesn't matter whether it's a peremptory law. And secondly, yes it is. Now, going back to my learned friend's helpful description of the hierarchy in international law rights, an erga omnes right, a right which engages the responsibility of all states and all international organisations, is what the Court of Justice said existed here. That's paragraph 180. That's how they categorised the relevant rights. And then what they said is it was for the General Assembly to pronounce on the modalities. And, importantly, it was then for states to cooperate with the United Nations to put those modalities into effect. What happened then, of course, is the General Assembly did pronounce, and we have that, the court has seen it, it's page 3206, and the General Assembly resolution explains that the administration has to cease, and importantly, at paragraphs 6 and 7, both states and international organisations are called upon not to recognise acts of the, quote, British Indian Ocean territory. So, the question of recognition of acts, which my learned friend Sir James placed a lot of reliance on, was before the court. And some of the parties before the court said the court should have said that the UK acts should be non-recognised. The court said, not a matter for us, it's a matter for the General Assembly. The General Assembly picked that up and answered that question in paragraph 6 and 7 of their resolution. So the consequences in international law are clear, and they include, as a result of the kicking it over to the General Assembly and the General Assembly's answer, non-recognition. Now, it's quite right that some of the judges in the court would have gone further and said, we are actually going to decide and say as a matter of international law, non-recognition. We don't think it's a matter for the discretion of the General Assembly. That's all very interesting, but in light of the General Assembly's resolution, it's not important. Then, is it a peremptory law? Yes.
Sorry, did you suggest that the resolution requires other bodies to not recognise?
Yes, it does, and that's. Can I take that up, my lord? It's Supplemental Authorities, Volume 3, at tab 60.
Can I have the page number if that's all right?
Sorry, my lord, page 3206, Supplemental Authorities.
Is it paragraph 5, refrain from impeding?
No, it's paragraph 7, which is the provision which would apply to the convention machinery, which is calling on all international, regional and intergovernmental organisations, including those established by treaty, to recognise that it forms part of the territory of Mauritius, support decolonisation, and then importantly, to refrain from impeding that process by recognising or giving effect to any measure taken by or on behalf of the British Indian Ocean territory. So that's the non-recognition.
It's a call, not an obligation.
Yes, because the General Assembly can't impose a binding legal obligation on states, but what it can do is it can state, in consequence of the question being essentially kicked back to it by the International Court of Justice, what it says the consequences ought to be. And its call on international treaty bodies is not to recognise acts in relation to the territory. So the question having been sent back to them essentially by the court, they went as far as they possibly could have done with international law.
That's not an exercise of Article 40 of the Charter. It's not an Article 40 exercise, but it comes pretty close to it.
Yes. And then finally, as to whether or not it is a peremptory norm or not, I'm afraid that the appellants don't consider that the Secretary of State gave you a fair presentation of international law or the views of the International Law Commission. The International Law Commission have published very detailed work on what norms are peremptory norms, and it is absolutely the case that the right of self-determination is there. And the key and most recent detailed piece of work on that question is in the next tab to the one we showed you. It's tab 39 of the Court Authorities at page 1935. I won't take you to it, but the right of self-determination is described as a classical norm of Jus Cogens whose peremptory status is virtually universally accepted. And then there's numerous pages of analysis as to exactly why that conclusion is reached.
But if that is so, why were the judges divided over that issue? It would appear in the advisory opinion.
Well, I'm not sure it's necessary to go as far as saying they were divided over it. It's simply that in order to impose an Erga omnes obligation, which is all they needed to do, they didn't need to expressly make that finding, and it just simply arises out of the usual judicial caution of not needing to formally decide more than you need to in order to deal with the issues in front of you. But it's certainly the view of the International Court of Justice in previous cases, which are cited in the ILC's work, that it is a peremptory norm. And several previous ICJ advisory opinions to that effect are cited in the reference I've just given you. Equally, it's also been found to be a peremptory norm by numerous other courts. And so it just simply wasn't necessary for the court to go that far or to say that in that case. It was enough to say it was an obligation Erga omnes, because that is what triggers the potential rights and obligations on other states and treaty bodies. In the minute or two I have left, can I just make a couple of conclusion points on the remaining points that were made by Sir James? First of all, whether the advisory opinion is declaratory or prospective. Well, there's no suggestion in the advisory opinion that it's prospective only. The General Assembly resolution they relied on, 1514, dates from the 1960s, and they said that the relevant norms of international law had been crystallised by the time of severance. And at 177, it was said that it's a wrongful act of a continuing character. What does continuing character mean? Since 1965. And then, of course, the General Assembly explained in May 2019 what those obligations meant. And then finally, on the advisory opinion, reliance is placed on the Arantaz-invented line of authority about the United Kingdom speaking with one voice. That is an argument which has been repeatedly taken by the Secretary of State in cases where issues of international law arise under the Convention, and it was decisively rejected by the Supreme Court in Ben Carbuche last year. The reference to that is 2019 Appeal Cases 777 at paragraph 35 of the judgment of Lord Sumption, where he explains that argument. He explains why when international law issues arise under the Convention and they need to be resolved, the court simply has to resolve them. Because the Convention jurisprudence has always recognised international law as informing the proper interpretation of the Convention. And there's a very detailed analysis that follows about the condition that may apply in other kinds of cases. Given the time, I'm not going to reply on any of the other issues, but unless I can assist your lordships any further, those are sufficient.
Lord Justice Green.
Thank you very much.
Lord Justice Dingemans.
May I just ask, what do you say the answer to Sir James's reliance on the arbitration proceedings between Mauritius and the United Kingdom is?
Yes, I'm afraid I looked at the references which he gave briefly whilst he was giving them, and I'm afraid I didn't see the relevance of the references. And so it's seem to support the points which you made. I may need to go back and check those references again, or I may have written them down properly. I looked at them over the short break.
My understanding of his point from that was that arbitration could be another source of public international law, which I suspect is common ground, and that what that suggested was that the United Kingdom's occupation was still lawful while there was a defence purpose. But as like you, I haven't read in detail the award.
If that is right, and the paragraphs which we were referred to do not seem to bear that out, and do not seem to make such a finding, of course, that that issue wasn't even before the arbitration panel, because it was dealing with the law of the sea relating to the waters of the British Indian Ocean territory. But that can't survive the advisory opinion. And of course, to the extent that was a good point, it could and should have been made to the International Court of Justice, who would no doubt have dealt with it.
Well, I think it is the case that the ICJ had expressly addressed that point and said why, notwithstanding the arbitration agreement, it would still go ahead with the advisory opinion.
I mean, it's absolutely the case. Oh, sorry, Michael.
No, it's all right. The court decided that there was a different point decided in the cross arbitration, and in fact, the reference to the United Kingdom returning the islands after defence needs were met is a reference to the arbitral panel finding that an undertaking given by the United Kingdom in the Lancaster House meeting was in fact binding in law. Yeah. So it was not to do with self-determination rights.
Exactly, and that was when I looked at it, was what the references that Sir James seemed to go to, which didn't seem to support the proposition which he was putting forward.
All right, we better let Ms. Kaufman have her few minutes that are left. Thank you very much, Mr. Chaffee. Ms. Kaufman, you've been squeezed by everybody.
I have indeed. I'm going to try and get through this as quickly as I can, but I'm going to be going quite fast. Can I start with the right of the vote? It doesn't seem to me as though there is very much between the respondent and the appellants on this. The respondent didn't seem to take issue with the right of a vote being a right that is embedded in the common law. Rather, the focus of Sir James's submissions was on the legislative scheme in BIOT, and really it seems to have come down to the 2004 order and its provisions being incompatible with a right of a vote because they expressly take the right away. That is precisely the same premise from which we begin, and your lordships will recall that we traced the legislation in the BIOT in our opening submissions, showed that certainly post-1983, when the document of tab 2, the 1983 order, brought in the common law in the BIOT, and without any question, after 2000, when the right of a vote was restored effectively through the 2000 order, there was no inconsistency between the common law and the legislative framework in BIOT. And it is therefore solely because of the 2004 order that the right has been extinguished. What Sir James didn't answer was any of our submissions as to why, despite the fact that the right is not in existence at the moment in BIOT, these decisions did not engage both the decision maker and the court in anxious scrutiny, because those rights, or that right, remains in issue. And so we simply repeat our submissions. And can I then turn to the right to self-determination, where there were two routes, your lordships will recall, two routes to the requirement of anxious scrutiny. One is in relation to the precise same argument that this is a right, which is a right as a matter of customary international law, and then through the cases of Jones and KU, it is a right that the domestic courts are entitled to look at, and in terms of the development of the common law. So that's the first route. But the second route, and again, a route to which Sir James had no regard, is the route by Smith, that as a matter of customary international law, as a right that is extended solely on the international plane, it is nonetheless one which a decision maker is required to take into account and which the court is or is required to have regard to in addressing the way in which the decision maker approaches the decision making. And Sir James didn't address, save to refer to Lord Hoffman, who didn't touch on this point at all. Lord Hoffman solely looked at the common law route by which customary and international law finds its way into judicial proceedings domestically, and didn't address the route of Smith. Can I focus then on the right to self-determination and the points raised by Sir James about that? The first very important point is that he conceded that the right to self-determination is a right as a matter of customary international law. What he didn't concede was the way in which we have characterised that right as being a right of the Chagosians in respect of the Chagos archipelago. And what he also didn't concede was that an aspect of the right to self-determination, a necessary part of that right, is a right to resettle in territory that you have been removed from in breach of your right to self-determination. Whether or not he's correct in relation to resettlement, it is absolutely clear from the ICJ opinion that the right to self-determination is a right that is enjoyed by the peoples of a territory, and that is clear from paragraphs 159 to 160. This is called tab 36, and the relevant pages are 1719. The relevant page is 1719. And 159 is relevant because the court sets out what had been argued and what it's going to address in 160. Some participants have argued that the customary status of the right to self-determination did not entail an obligation to implement that right within the boundaries of the non-self-governing territory. And we can see, and we looked at this, the bottom part of page 160, after having identified the customary status of the norm, the court considers that the peoples of non-self-governing territories, this is 5 lines from the bottom, are entitled to exercise their right to self-determination in relation to their territory as a whole, the integrity of which must be respected by the administering power. So it's quite clearly a right of the peoples, albeit it was expressed in proceedings between Mauritius and the United Kingdom, but it is the right of the peoples of Mauritius. And that included, at the time that BIOT was created, all those peoples of Mauritius who were occupying the archipelago. And we also submit that it is necessarily implied, it necessarily follows from the way in which the right to self-determination is expressed in paragraph 160, that insofar as individuals who enjoy that right have been removed from the territory over which they are entitled to express the right, then it necessarily follows that making good that wrong because of its invasion of the right to self-determination necessarily requires that there is a right of resettlement. And we submit that that is made clear again in the judgment, and this is a point made by Lord Justice Green yesterday when looking at paragraphs 179 and 181 and how the two fall to be read together, and we endorse that reading. We also dealt in our skeleton argument, and I'd ask the court to read those parts at paragraphs 34 to 35 with other jurisprudence which is relevant to establishing that necessary connection between the right to self-determination and the right to resettlement. So, however one characterises the right as a right to self-determination or as a right to self-determination which includes the right to resettlement, it is something that is enjoyed by the Chagosian people themselves, and something which, therefore, as a matter of customary international law, is something which our courts are entitled, and not just entitled, but should have regard, either through Smith or through the common law route, which I'll come to briefly. But first, I want to look at peremptory norm. And like Mr. Jaffe, our answer to that is, so what, whether it is a peremptory norm or not? It makes absolutely no difference to the arguments relying upon the common law or relying upon Smith as to the significance of this and its bearing on anxious scrutiny. It is enough for the common law route that it is a norm as a matter of customary international law, and equally in relation to the Smith route, there is nothing in Smith or in any other cases that have followed since to suggest that it is only peremptory norms of international law that give rise to an obligation for anxious scrutiny when decisions are taken which have a bearing upon those rights or interfere with those rights. And so if we look at, for example, Smith itself was dealing with Article 8 under the European Convention of Human Rights, which is not itself a peremptory norm of international law, but nonetheless the engagement of that right and its potential interference had a bearing upon the way in which the decision maker in the court had to consider the issue. The arbitral award and the tension with the ICJ judgment, your lordships have just addressed that briefly, and I don't think I need to add anything to that. They were not looking at the same issue. And plainly, the ICJ opinion is the authoritative opinion on the status of customary international law, and it is for that purpose that we rely upon it. Finally, the 4 points that Sir James made on anxious scrutiny, specifically in relation to its application via the right of self-determination. Firstly, he said the ICJ opinion was not delivered at the time when the resettlement decisions and the right of abode decisions were being looked at by the NSC. But that is irrelevant, because the purpose of reliance on the ICJ opinion is for what it says about the nature and status of customary international law, not just at the point at which the judgment was speaking, but also at the point in 1965 when BIOT was created. And I remind the court, as I highlighted in opening, that, or Sir James did, somebody did, that Sir Sidney Kentridge raised the right to self-determination in Bancoot number 2 as a matter that needed to be taken into account in relation to the decision-making. What Sir Sidney did not have at that time was the ICJ's opinion, which is now an authoritative statement as to the status of the ICJ, of the customary right.
But I assume, at least as James, I think, said this, I assume that opinions of the ICJ, which give a result that becomes customary international law, they aren't like the common law principle that you're always uncovering things that have always been there. They presumably, customary international law does change from time to time and develops.
It does, but what the opinion says in terms was that the status of customary international law in 1965 was settled, and there was already in 1965 a right to self-determination as a matter of customary international law, and that is what Sir Sidney argued back in Bancoot number 2. It is simply the case that the ICJ had not given an authoritative opinion. Our point is this court needs to look no further than the ICJ opinion, because it is so authoritative as to the status of customary international law back in 1965. Second point that Sir James raised in relation to the right to self-determination and anxious scrutiny is that the UK should speak with one voice in the international field. Well, he took us to no authority that would preclude this court from identifying the right to self-determination as a right, as a matter of customary international law. And we deal with this more generally in our skeleton, and I'd ask the court to read that, but there is no duty on this court, or no prohibition on this court, from expressing a view as to how the United Kingdom is conducting itself on the international plane. And it's vital at this point to reiterate something which Sir James elides at times. It's vital that the court understands we are not relying upon the ICJ opinion as establishing any rights that this court has to give effect to at all. It is simply relied upon because it articulates a right that this court is entitled to find is enjoyed by, is possessed by the Chagosians, and that therefore has a bearing upon the decision-making process, which remains that of the Secretary of State at all times. Third point, no correspondence between customary international law and the rights, the nature of the rights considered by the ICJ as customary international law and the matters and issues in this case. Well, I've addressed that. It is a right of the people of Chagos. It does include a right to resettle, but even if it doesn't include that right to resettle, a right to self-determination is sufficient. And the final point is the one I have just agreed with. The obligation neither creates nor supports the existence or breach of a direct legal obligation. I fully agree, and we don't rely on it for that purpose. But that isn't to say you cannot, the right does not have a bearing upon the decision-making process by requiring anxious scrutiny. So can I turn then to anxious scrutiny? I'm aware I have 2 minutes, which is really unfortunate. I would beg the indulgence of the court just for a few minutes over the 4:30 deadline.
Well, we'll give you another 5 minutes.
I am very grateful indeed. Firstly, his first point was, look at WM. WM is wholly unsupported by the case of Bud Decay, on which it drew support, to which our answer is, fully in agreement with the points raised by Lord Justice Green, that it's implicit in the Bud Decay case that the decision maker himself or herself must also engage in the decision-making process using anxious scrutiny where fundamental rights are engaged. And I would ask the court in its own time to look again at that decision, to look at Professor Craig at tab 62, particularly page 3235, where he looks at both Bud Decay and WM as two foundational cases in setting out the relevant principles that govern anxious scrutiny. And Sir James very faintly tried to distinguish the WM case on the basis that that was a case where the Secretary of State was having to second-guess the decision-making of another court, and it was because the case involved the decision-making of a court that the Court of Appeal and Lord Justice Buxton had talked about anxious scrutiny being required on the part of the decision-maker. I say he did so faintly because in my submission that is quite obviously not a basis to draw the distinction. The respondent, all the way through his submissions, understandably focused on the role of the court, precisely because this is a case where the court clearly, as we have acknowledged at all times, needs to stand well back from questioning the substantive decision-making involved in this case, precisely because it is a decision that includes a multiplicity of policy-laden choices. Choices about environment, choices about social costs or benefits, choices about financial costs, and then issues relating to defence. And he's right to suggest that we don't question the balance that was made. But our focus is on the decision-making process, precisely because this is an area of decision-making where there is so much in the way of policy choice and so forth. It is vital that, because it does engage fundamental rights at the same time, that the approach taken to the assessment and the determination of where the balances lie in relation to all those multiplicity of macro interests is taken in a way that properly evaluates the facts with the necessary care to ensure that the decision has proper regard to those fundamental rights. That has been our focus, and that remains our focus. Next, he said, well, the question of relevance in relation to any irrationality challenge is always that for the decision maker, and we accept again that generally, unless the statute speaks to the matter and identifies precisely what matters are relevant, or it is so obvious by virtue of the nature of the decision what is relevant, then it's up to the Secretary of State or up to the decision maker as to what they take into account. But where anxious scrutiny is required, it is precisely because there is a factor which is obviously relevant to the decision, and that is the fundamental right which is at stake or engaged. And that is why the decision maker is not simply free in this decision-making exercise to choose whatever factors he wants to consider. He has to look at and take account of the fundamental rights that are at stake. In relation to right of abode, he said that, and he paid a lot of regard to what Lord Hoffman had said at paragraphs 53 to 58, that you have to look at the decision in the context at the time. Sorry, you have to look at the right in the context at which it is being considered, at the time that it is being considered. And we agree, and that's precisely how we have approached the matter. We have spoken about the decision maker having failed to take any decision in relation to the nature of the right of abode as it might exist now. And as it might exist now, the right of abode is a right which continues to have a symbolic value.
Well, you made that point.
Yes, but the point made by the respondent in relying on Hoffman's judgment is that this was a right of so little value that it doesn't really need to be considered at all. But what Lord Hoffman was doing in those passages was looking at whether or not a right which has so little bearing in terms of its practical realisation can possibly outweigh all the other factors that count against it. That's a different question to the one which the Secretary of State was obliged to ask himself here, which is, given that there is the possibility of resurrecting the right of abode, how does the value that it could enjoy in the here and now, albeit it cannot be practically exercised because resettlement is not going to take place, what are the costs against the realisation of that right? And as I said, that exercise was never gone through, despite the fact that the right was engaged and had to be looked at. Next, he said that in any event, the right to self-determination was at some level addressed. Well, it wasn't addressed by the decision makers. That is absolutely clear. The documents that you were taken to yesterday, which were a document from 2015, February 2015, relating to advice that was given to the meetings in 2015, did make reference to the possibility of allowing the right of abode to be restored, even if there wasn't resettlement. That document might have been before the decision makers in 2016, both the NSCO and the NSC. We accept that, but what was not before the decision maker was any choice about restoring the right of abode. And I took your lordships to the three choices that the decision makers had before them, and the only three choices that they considered, and those were resettlement on the outer islands, no resettlement, and the resettlement package. So they were never given that option. But finally, and very, 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 very quickly, on the airports, yes, the KPMG report made some reference to airports. You were taken to a passage in the main report yesterday. That passage said nothing in any detail about the viability of building airports. You would have to have gone right to the end and to the appendices in order to look at any detail about building airports. The likelihood of that having been done by any member of the NSC can, frankly, be discounted. But the proof is in the pudding. There was no reference whatsoever to the error made about whether or not an airport could be built in any of the minutes or in any of the CCR documents that we were taken to yesterday. At no point was that error remedied, and no doubt that is because it simply wasn't picked up. And they did proceed on the basis that an airport could be constructed. Now, if you are going, despite the KPMG report, to look at the viability of the outer island resettlement, then the viability of building an airport, the costs of building that airport, which it was accepted by Mr. Hayes were never ever looked at, are clearly matters of the utmost importance. Considered together with the viability of the tourist industry taking off in the outer islands in the first place. And on that footing, one of the points that were made yesterday by Mr. Eady, and it was a point made in the judgment of the Divisional Court themselves, the paragraph paragraph 235 of the Divisional Court's judgments on page 239, that the outer islands option would require huge infrastructure costs. That was an assumption that was made by the Divisional Court and by Mr. Hayes in the passage that you were taken to yesterday. That's paragraph 21, page 855. But if you actually look at the Whitebridge report, it is quite clear on page 41. No, I'm so sorry. Let me get the actual page. I'm sorry, this is the last point I'm going to make, but I do want to correct this because it was an important factual point made by Sir James yesterday and the Divisional Court about which all goes to the possibility of the viability of the outer islands ever providing an economic basis for reoccupation. And it is in the supplementary bundle, and it's the Whitebridge report, which is at tab 31, and it is page 304 and 303. And I'm not going to take your lordships to it now, but I would ask your lordships to please read those pages 304 and 304 and compare them to what Mr. Hayes says at paragraph 21 of his second report, second statement, because there is a clear inconsistency there. And again, I reiterate, if you are going to consider the outer islands, then it's vital, if you're meaningfully going to do so, you do so on a factually correct basis. And that didn't happen. Unless I could be of any further assistance. I'm so sorry to have crept on and on and on a Friday afternoon.
It was an elastic 5 minutes, but that's fair enough. Thank you very much indeed. Any questions from the other Lord Justices?
Could I just get the page reference you gave for the supplementary bundle for the Whitebridge report?
Yes, so the Whitebridge, the relevant pages are pages 303 to 304.
In the supplementary bundle?
In the supplementary hearing bundle.
Okay, thank you very much.
One, Whitebridge. Whitebridge starts at 282 and it's pages 303 to 304, which are the key pages. And the relevant passages in Mr. Hayes are in his second statement at paragraph 21, which is at page 854.
Thank you.
And that was picked up by the Divisional Court, and it was a point reiterated by Sir James yesterday.
Lord Justice Green, any questions from you?
No, thank you.
Very, very grateful to Ms. Camp. We're extremely grateful to all counsel for their extremely helpful and very high quality submissions on this important appeal. We will consider our judgments. We will, of course, in due course, hand them down, no doubt, depending upon the timing of it, remotely probably. But obviously, if we can hand it down in some other way, that will be all the better, but maybe remotely. In the usual way, please, when you get it, agree a form of order. Any further submissions are only to be in writing unless we ask you to do otherwise. But we thank you. We thank the many people in your teams that have worked so hard in these rather difficult circumstances to make this remote hearing possible. And we will endeavour to produce judgment or judgments as soon as possible. Thank you very much.